Thank you, Mr. Chair. Colleagues, when the Voting Rights Act was enacted in 1965, voter registration rates for Black Americans in the South were abysmal up until that point because of the discriminatory laws and policies that made it effectively impossible for them to register. I point this out because, largely because of the Voting Rights Act, things have undoubtedly improved since 1965. Indeed, more Black voters were added to the rolls in the first 2 years following passage of the VRA than in the previous century. But significant barriers to ballot access remain, and some communities, particularly communities of color, feel the effects of these barriers more than others. After 4 decades of, and I want to underscore this, after 4 decades of overwhelming bipartisan majorities of Congress affirming the need for the Voting Rights Act with several reauthorizations, and in reauthorizing, acknowledging the need for federal protection of the right to vote, including through preclearance, protecting the right to vote through preclearance. That happened repeatedly over the course of more than 40 years. But today, we find ourselves in a place where the Republican Party line is now that federal protection of the right to vote is tantamount to an unconstitutional federal takeover of state elections. My question, Ms. Clark, is this. In Shelby County, the Supreme Court struck down the coverage formula to determine which jurisdictions have to submit to the preclearance requirement. But has the Supreme Court ever held preclearance itself to be unconstitutional?
Thank you, Senator. No. It essentially gave Congress the task to go back to the drawing board to fashion an approach to coverage that tethers the preclearance process to current conditions. And we know that Congress has been carefully studying this issue over the last few years, developing a record that makes clear ongoing voting discrimination remains rampant across the country. And it is not unusual for Congress to respond to a court ruling. We saw that with the Civil Rights Restoration Act and the Lilly Ledbetter Fair Pay Act. So the department welcomes this opportunity to work with you to update the coverage formula in response to the court's Shelby ruling.
Because conditions have changed since 1965.
Conditions have changed, Senator, but we know that voting discrimination remains ongoing today.
I understand. At the risk of going off on a tangent here, because I think we can apply that logic even more strongly when it comes to the Electoral College, but that's a conversation for another day. Back on this topic. From a resource and a timing perspective, I'll call it a damage done perspective, can you spend just a minute on the benefits of a preclearance requirement versus a post-enactment litigation?
Well, Senator, the burden on voters is undeniable. A discriminatory voting tactic may have taken root and infect the electoral process that's playing out in a community. We know that states have spent millions of dollars defending suits. In Texas, they spent $3.5 million defending the discriminatory voter ID law. In North Carolina, more than $10.5 million spent defending their omnibus bill that the Fourth Circuit found discriminated with almost surgical precision. The Section 5 preclearance process is swift, it is easy, it is cheap for jurisdictions to comply with it, and it leaves Americans with the benefit of an electoral process that is free from discrimination.
Great, thank you. Mr. Chair, I want to ask one more question on what may seem to some as not necessarily a voting rights element of this, but it is fundamentally one, not how people can cast their ballots, but as it pertains to the census and the redistricting process, which is pivotal from a voting rights perspective. Census data shows that the Latino population growth over the last decade fueled the population growth of states throughout the country. In California, for example, data shows that between 2010 and 2020, Latinos accounted for more than 2/3 of the state's population growth. Places like Texas similarly experienced significant growth of their Latino communities. Accounting for Latino population growth in redistricting is therefore critical to ensuring fair representation. But this redistricting cycle is unlike any other in the past 5 decades. For the first time since 1965, in light of the Supreme Court's decisions in Shelby County and Brnovich, states will conduct redistricting without the full protections of the Voting Rights Act. So, Ms. Clark, my question is, what remaining tools does the Department of Justice have to help ensure a fair redistricting process, and how would the department's efforts be enhanced by the passage of the John Lewis Voting Rights Advancement Act?
Thank you, Senator. Essentially, we would have Section 2 of the Voting Rights Act at our disposal, and this is not an adequate substitute for the important protections that had long been provided by Section 5. This case-by-case approach simply is not enough to stand up to the breadth and scope of voting discrimination that we see today. And if I may, I just want to underscore the importance of Section 5 when it comes to redistricting. The department had issued an objection in East Feliciana Parish, Louisiana in 2011 involving a proposed redistricting plan that would have reduced the Black voting age population of a particular district. The department found evidence that the demographer in this matter worked exclusively with white elected officials in coming up with a plan in which they reduced the Black population and increased the white population, and they excluded Black elected officials in the course of drawing this map. This example illustrates the important role that Section 5 plays at the local level, at the local and county levels that are often places that are not under a microscope, but places where the department has found that voting discrimination has been rampant throughout the test of time.
So, thank you. Thank you, Mr. Chair.
Thanks, Senator Padilla. And